President Professor Kindiki is vehemently opposing any plans to overturn the impeachment of his predecessor Gachagua, saying it will lead to a constitutional crisis. His legal team tore into Gachagua's prayers to the court, including compensation and benefits. Martin Opio reports.
Directed.
Thursday marked the fourth day of hearings challenging former Deputy President Gachagua's impeachment. Deputy President Kindiki, through his lawyer Muthomi Thiankulu, opposed Gachagua's prayers that are seeking to overturn his impeachment.
It is prayers of a type that if you were to grant them, they would plunge us into a constitutional crisis because if you grant the other petitions, you have to reinstate him, something he doesn't want. If you quash the motion, it means he is reinstated by operation of law, which again, it doesn't want.
But Gachagua, through his lawyer Tom Masharia, dismissed Kindiki's arguments, saying Gachagua had dropped the request to be reinstated. This would, however, attract the attention of judges.
Yes, my lord.
Why do you want to limit our orders?
I'm not limiting your orders.
But we can return.
Oh, well, my lord, that would be a most happy surprise. We will receive all gifts.
Court cannot avoid a decision because it approaches the boundaries of the Constitution, ditto political questions.
Kindiki's legal team has opposed Gachagua's compensation prayer, which is a 35-month payout.
There is a recent Supreme Court decision that says you cannot award damages for anticipated earnings, even if you were to find that his removal was unconstitutional, null and void. That is the decision of the Supreme Court, my lord, in a case called Gokonyo and two others versus Telkom Kenya and others.
In his pleadings to the court, Kindiki claimed that Gachagua faked his illness to avoid cross-examination at the Senate, terming evidence by cardiologist Dr. Dan Gikonyo as inconsequential.
If the petitioner had dared turn up for that cross-examination, it would have dispelled the facade that is his trademark of a honest man. It would have shown the terrible things he had done to his own relatives, including disinheriting his late brother's children and widow.
I think it's misrepresentation to suggest that there was no evidence, that this question of health did not arise at all. And so the decision to proceed without hearing him, without hearing the Deputy President, was a deliberate violation of his Article 50, Article 47 rights.
The Senate also disputed Gachagua's claims on timelines, insisting that it was within the required time frame to conduct the impeachment.
There is absolutely no time, and I have been listening very carefully. My learned friends for the respondents have avoided studiously, carefully, painfully even, to tell you where this timeline they're telling you is in Article 145 for plenary. There is no timeline given for plenary. Again, to make it clear, we are not saying it is to be open-ended forever. We are saying it must be time that affords you a fair hearing under Articles 47 and Article 50.
The case resumes on 22nd of May.
In the interests of time.
Martin Opio, KTN.